Thank you. Hello, everybody. This is the first webinar for the 2024 Protecting Your Employee Assets, the Life Cycle of the Employment Relationship. This is welcome to the team recruiting and hiring, including restrictive covenants. I'm Chuck Krugel. I'm the moderator, as for the last number of years I have been. And a few introductory remarks. This webinar is part of the Financial Poise series. I already mentioned the 2024 Protect Your Employee Assets. Slide number 8 of the PowerPoint provides a summary of the series, and slide number 7 summarizes this episode. Slide number 5 is our disclaimer. And as we always remind you that you can't go out and make important business decisions based on what you learn in today's webinar. We're not your advisors or your attorneys. You're not our clients. The information that we present here is meant to give you general knowledge to help you select and work with advisors of your own choice. Also, regarding the slides, understand, and as always with our webinars, we don't lecture or present off the slides. We will be showing the slides while we go through the presentation of the webinar, but you don't need to actually be on any specific slide yourself or read the slides even to understand the webinar. This is an independently presented webinar, and it's a conversation between the four of us. More about Financial Poise, too, if you want, is on slide number 41. Our panelists this year, and we have 2 returning panelists and 1 new panelist. So we have Max Barak, partner from the Garfinkel Law Group. Amit Bindra, our newest presenter, is a partner from the Prinz Law Firm. And Helen Black, another returning panelist from the law offices of Helen Black. And again, I'm Chuck Krugel. However, we know you're not spending your time and money to hear about us and to hear us talk about ourselves. So you can read more about us on slides 35 through 38 of the PowerPoint. If you're attending the live premiere of today's webinar, you could submit your questions using the web portal on demand or via email. You could also send it to info@financialpoise.com. Just include your question and the name of the webinar episode, and we'll do our best to get you an answer, either live or after the webinar. And always, we like to thank our sponsors. This year, we have some new sponsors. Thanks to Mood Online Dispensary. You can find out more about them on slides number 33 and 39. I'm actually under the influence of their products right now, and it's terrific. Right. Also, Type to Learn. They're one of our returning sponsors. By the way, that was a joke. Type to Learn, it's a digital learning solution provider. It's fine, you can laugh. Just don't take it seriously.
They can verify it with the video now. I mean, before you could have been in a cloud of smoke and nobody would have known, but now they can see.
Well, yeah. What if he took an edible?
By the way, that's fog behind me. That's not smoke. So, just so you're all clear on that. All right. So anyway, one of our other sponsors is Sunburst Digital at sunburstdigital.com. They have the Type to Learn platform, which is a digital learning solution provider. More about them on slides 4 and 40. And our third sponsor is Max X Asset. It's a simpler, easier, and better way to conduct asset sales in insolvency proceedings. They're also on slides number 4 and 40. With all that said, now let's get into the actual substance of this. And we'll start out with Amit. So over the past few years, we've seen a real big change in how state legislatures and courts view employment agreements. This is in particular emphasis on post-employment restrictions like non-competes and non-solicitations. It seems like they've lost favor with law enforcement. What's your take on this, and where are we headed as a society relative to these?
Well, I'm happy to join the group, and you can tell we're a bunch of attorneys, so we have to start with a disclaimer. So this question, I feel like, could be an hour. I've definitely talked about this for an hour, so I'll try to hit the high notes as much as I can. Non-competes are a unique space because you can have bipartisan support. Companies also need to hire folks. And so non-competes also restrain or impact free trade. There are libertarians out there who don't support these types of covenants. So you get this weird Venn diagram of overlap between different interest groups. The short answer to your question, Chuck, is that legislatures and courts are going to try to continue to chip away at these agreements and these clauses. So companies need to be proactive about how they protect their information. And I'll limit my longer answer to only about 12 years of history, which is that about a dozen years ago or so, Jimmy John's made the news because they were making their sandwich makers who were making close to minimum wage sign non-compete agreements. And so that led state attorney general's offices to look into the issue, to ban agreements for low-wage workers. For example, around that same time period, Illinois passed the Freedom to Work Act, which banned non-compete agreements for folks making minimum wage or slightly above minimum wage. The Obama administration also started beginning to look into the impact that non-compete agreements had on trade and employee mobility. So from there, you now saw states banning or passing legislation to ban non-competes for low-wage workers. The next stage in that evolution over the last decade was to increase the salary threshold. Because logically, it just didn't make any sense to have non-compete agreements for someone making, let's say, 50 grand a year. It was the same logic as someone making slightly above minimum wage. So then the next trend was to only allow these agreements for higher wage earners. Washington State, Colorado, Illinois, Washington, D.C. then passed laws that would only protect or only allow provisions for higher wage earners. Those laws also included some other benefits. They were more stricter in terms of their requirements. For example, Illinois, our law, which is where we are all located, requires some additional benefits for non-compete. There's notice requirements. There's an attorney's fees provision if the employee wins the non-compete lawsuit. So that was kind of the next trend. The current trend in terms of non-compete litigation and non-compete laws is to ban them altogether. So Minnesota this summer became the fourth state in over 100 years to ban non-compete agreements. New York State's legislature passed a law, but the governor vetoed it. That law will likely pass in some capacity. It'll just be more in the range of higher wage earners. The FTC proposed a rule to ban non-compete agreements as well. And in NLRB, the National Labor Relations Board, also issued a legal memo last year because they were concerned about the broad impact non-competes can have on an employee stuck in a bad work environment. And courts have gotten involved. Surprisingly, Delaware, which is supposed to be pro-business and pro-contract, had a trilogy of cases from the fall of 2022 through the spring of 2023, in which Delaware courts limited enforcement of non-competes, including in the context of a sale of business. And then Illinois was another state that developed case law regarding the benefits an employee needs for a non-compete. So with all that being said, to circle back to the original question, companies need to conduct audits to ensure that their folks are that the right people have access to the right information, that their information is being protected, either through passwords or some other means, that there's training. And the biggest thing I always stress in these circumstances is that companies, that the legal side and the business side of companies talk to each other so they can understand what is actually important to protect. And so the key information can be protected, because sometimes there is a solution that's not going to be, let's make all of our minimum wage workers sign a non-compete agreement.
Outstanding, Amit. Thank you. So moving on, Max, let's take a bigger picture focus here and look at the risk and pre-employment. So what are the biggest or costliest areas of exposure for employers in the pre-hiring phase?
Thanks for having me back again this year, Chuck. It's good to be back on these webinars. I'm going to just start by saying non-competes and restrictive covenants that may not be enforceable or may be enforceable in part are one, but that is not my area of expertise. That is, Amit literally helped write the amendments to that law in Illinois and litigates this nationwide. So I will just mention everything he just said, and that can be a major driver of cost and headache for businesses and their legal departments alike. Setting that aside, there are a lot of different things. More general issues that I think can down the road lead to legal consequences are more logistical and less something your lawyer might tell you, like setting clear expectations for new hires, making job requirements clear, making sure all of that is documented, making sure the responsibilities and obligations, both as to matters like non-competes or other restrictive covenants, confidentiality and what have you, personal use of company information and devices and the like, are clearly communicated and their communication is documented internally. These things can spiral from there. In addition to the restrictive covenant work, we have things like ban the box legislation, which I think we're going to talk about more in detail later, but basically asking as a general matter, impermissible questions at the hiring stage or basing decisions improperly or illegally on questions or information you're not supposed to have or ask. There's other matters that are newer. We're going to do a webinar on emerging tech issues, including AI. But there is a recent, what we call a consent decree, basically a public settlement between the federal government, the EEOC, and a foreign company that was using AI to sift through job applicants in a manner that was discriminatory. It was, I can't remember the exact specifics, but it was essentially sorting applicants by age and possibly gender as well. So even when you're using machines to do the onboarding and when you get to the pre-employment stage, these are all things that you need to be mindful of. Lastly, I would talk about just paying people less for the wrong reasons and what kind of notice you give to employees. Our state, Illinois, has a biometric privacy law that requires you to give notice when you collect employees' biometrics. So you need to basically be mindful of what are the notices we need to give employees when we hire them, and how do we make sure that as we bring people on and as we consider hiring them, we are being mindful of state, local, and more broadly, federal requirements to that effect.
Great, Max, thanks. So Helen, moving on to you. Social media has been really hot for a number of years now as a topic, especially in pre-employment screening. Where are we in terms of background checking candidates and sourcing candidates using social media?
Yes, thank you, Chuck. It is a hot topic, and in a way it does piggyback right into some of the questions that you asked Max. And what I mean by that is, for instance, how you try to find candidates and the use of social media could have a disparate impact on your hiring and therefore lead to discrimination claims. And I'll give you a perfect example about that. It was actually a recent case, and there have been many others of these kind of cases, but a very recent case that was brought by the Equal Employment Opportunity Commission against a company that is probably out of China called iTutor, with 3 different integrated companies. It provided English language tutoring to students in China, but it advertised in the US to hire folks to tutor people in China. And what the company ended up doing is, based on the algorithms that it used and how it programmed their tutor application software, it automatically rejected female candidates over the age of 55. And it rejected male applicants that were 60 or older. So here's a perfect example. For instance, when you asked Max about what are some of these risks pre-employment, is how you go about your interview process, how you go about advertising for your job, because essentially the employment process doesn't start once you hire someone. It actually starts before that, in your recruiting, in your marketing of the position, in the, let's say, criteria that you put together for your job. You want to make sure that it is non-discriminatory and doesn't have what we call a disparate impact on folks. So social media today plays a big role in that, not only in how you find candidates, as in the example of the iTutor group case example, but also things like searching for candidates on social media. When you get to the interview process, there are a lot of laws that, for instance, preclude you from asking a candidate for, let's say, their password. Now, one can use publicly available information to look up a candidate, as you would in, the good old days. Nothing could stop you from going to the courthouse and, looking up a file. It's publicly available. So you can use publicly available information, but anything more than publicly available, you've got to get permission. And some things you can't even ask. What I mean by permission is that if, let's say, you do want to do a background check or a criminal background check, you need to get the potential candidate to sign off on it. And you can't just do it across the board. You really have to seriously consider this candidate for hire to be able to even run a background check. And there's certain things that you can't even check. So for instance, arrest records in most states, off the table. You cannot even seek information about arrest records. Basically, it's limited to criminal convictions that are reasonably tied to the position, that have some relevance to the position. And we're not expunged, and so on and so forth. These are some of the kinds of things that you can ask folks to sign off on and do. And even, let's say you do that criminal background check and it comes back positive. Well, the inquiry doesn't end there. You have to provide the information to the individual, and the individual has an opportunity to challenge it, to question it, and to respond. So those are some of the things that I think about when you ask about social media and its use today, and how that comes about in the hiring process in the workplace.
Thanks, Helen. I'm just going to throw out a couple comments because this just came to mind. But you mentioned the word algorithm, and I suspect that we're going to be using that a lot more, not only in this year's webinars, but in future webinars. I would advise employers to do vetting of their, in the same way they would vet, and candidates do vetting of their algorithms or whatever algorithms they're using. I guess you could also in some ways call it validation, like in the same way that you validate a pre-hiring test or intelligence or personality test, something like that.
Right.
Vet the algorithm being used.
Exactly. And this is not the first case. And I just one other thing that I wanted to mention that I don't know who was about to speak. There are also certain laws on certain technology that you can use even in the hiring process. So for instance, AI, artificial intelligence. If you are going to use artificial intelligence in your interview process, you've got to get the candidate to sign off on it. They have to know that you are going to be using the AI. So there are different states that also have similar laws like that. Even with respect to the use of certain of these AI technologies in the interviewing and hiring process.
Somebody else?
I was just going to make a comment. I mean, this is not our AI presentation, though perhaps it should have been. But, ChatGPT has gotten a lot of publicity, both favorable and unfavorable. And the lawyers perhaps listening may be familiar with the famous case where the New York lawyer tried to brief using ChatGPT and got justifiably raked over the coals by the judge. But the information contained in ChatGPT, particularly the free version, is not always up to date, and you shouldn't just take it as gospel. So whatever AI or other software you're using, I want to echo what Helen's saying and vet what you're using and make sure that you're operating both as to the laws you're checking on pre-hiring activity and the actual process, whether you're asking information about candidates or what the law permits. Don't just go with what the computer tells you there, because the disclaimer in that program is going to tell you this is not always 100% accurate.
Yeah, great point, Max.
To that point, I think the data entered into it is pre-2021 or right around there.
Something like that. The paid version is more up to date, but it still tells you, like, don't use this as like an ironclad Google that you think every piece of information is vetted here.
Thanks, everyone. So Amit, we'll stick with you on the next one. Another hot topic is asking candidates about their salary history. That's always been a perfunctory topic in pre-employment selection. But again, I'm asking this question because that's changing now. So what's going on with the typical salary history inquiry, and why is this happening?
So I think to eliminate basically structural biases within pay, a lot of states, especially bigger states, have passed laws to ban an employer from seeking pay history. Asking for someone's salary history now is a legal risk, and it's not something employers should be doing for a whole host of reasons. And so not only can employers not ask for it, and no employers now don't provide it as part of their reference check. That's generally a good best practice. They will just provide dates of employment and title held, and they won't provide salary history itself. The workaround, which I think kind of solves the middle approach for both sides, is for companies to ask for salary expectations. So the company will tell prospective employees, what are your expectations in terms of this role? And this allows kind of the employer to understand generally what the role is going to be from a salary standpoint, but it also allows prospective employees to negotiate their salary and not be bound by past history or past salary. So it kind of solves the structural biases while also allowing companies to make business decisions.
Thanks, Amit. Max, another topic for pre-employment screening is criminal convictions, the background checking of convictions. And generally, employers are increasingly unable to ask about these convictions. They must wait until a conditional job offer is made to the applicant, or when they actually select that individual for the interview. What's the conditional offer that I just referred to, and give it some examples of that, and what's going on with the criminal conviction screening process?
Sure. So I think this touches on something Helen was speaking about earlier. You can't just do blanket unannounced background checks on every person who who applies to your company. There are certain notice requirements, and like Helen said, the movement now in state and federal law, in state laws, is typically towards you need to first make such an offer. So what would a conditional offer be? Basically, what it sounds like, that you have the job pending certain criteria are now met. We've made it through the interview process. You meet what we are looking for in this role. You've hit the prerequisites for education or experience or other qualifications. So typical, you know, the definition I come up with is essentially an offer made to a candidate that's contingent on successful completion of certain criteria or requirements. So what might those be? I think common ones are, for example, a background check, though you want to be very careful about that and tether it to the job and your state's laws. So some examples are like youth serving organizations, right? Will have a little bit more leeway to make such a background check because, for example, you don't want somebody with a history of abusing children or in any respect being hired to drive the bus or the school bus or be in the school or run the summer camp for, I think, pretty obvious reasons. Reference checks, employers contacting other employers and saying, hey, is this Chuck Krugel guy all right? Or what do I need to be worried about with him? Obviously nothing. Drug tests, certain states, I know marijuana is now, or cannabis is becoming increasingly legalized, but every state at the state level, but a lot of states still have some rules about certain industries can still require you not to use or can still ask you to test. Medical exams, there's laws about that, and the ADA, which we're going to cover in a later episode, is implicated, but sometimes physical exams can be part of an application process. Verifying credentials, confirming that you are legally able to work in the country. And then what Amit and Helen have been talking about earlier, which is restrictive covenants not being an impediment. So typically that would be the starting point.
Okay, thanks. And sticking with that topic, Helen, what are your recommendations for employers to handle background checks in states, counties, or cities that restrict the background check, and when when employers can ask such questions?
Right. Well, certainly employers can always explain to potential candidates what their criteria is going to be. So for example, while you can't ask someone, let's say, what their national origin is, one can always say, here's the criteria. You must be legally eligible to work in the United States. Another criteria could be, and you can even do this as part of your, not just the interview, but when you are, your criteria, when you are searching for candidates, you could put down one of the qualifications is that the successful candidate will need to submit to a background check. Now, again, I only recommend doing this if the kind of work or the kind of job actually requires, let's say, someone to have not have a criminal history in certain areas. So for instance, we use the example of working for children, teachers, working with the elderly, someone who's exposed or has access to really confidential banking information, and so on and so forth. So you really need to make sure that if you are going to do these criminal background checks, it should be narrowly tailored. And you can let folks know at the outset what your criteria is, if that is a criteria that you are going to run a background check on the successful candidate. So folks know what to expect going in. Now, you can't just require folks to submit to background checks. You really have to wait until you have that successful candidate and then run the background check. And one of the things that I would do is, if you're going to run that background check, is not only to let the individuals know, but tell them what to expect, let them know what their rights are under the federal Fair Credit Reporting Act. And I would give employees an opportunity to, let's say, explain any things that you might find, so perhaps let them know that we're going to find this. Is there anything you want to let us know in advance? Because sometimes if employees front the issue and explain what the situation is that might be found on a criminal check, it really might not be that big of a deal. But if you're to see it for the first time on a criminal check, it might look so much worse than what it actually is. And I have seen that personally. I have represented individuals who are executives that, let's say, got into an altercation with someone at a store or at a certain place, and the unfortunately the situation escalated and the police were called, and let's say it was out of state and you didn't want to go back to that state for some, for a criminal, trial. So you realized like there was no jail time, no nothing, and you just gave authorization for your attorney to plead no contest, and you just had to pay a fine or something that wouldn't be a big deal, but it still could show up on your background check. And the way it is written on your background check could really sound so much worse than what actually had transpired. So I would say to folks to really front the issue. If you know something might come up. And also what's interesting that I found out just in some of these situations in which I've represented folks is that not all background checks are the same. Different companies might have access to different types of databases. So you might think, I'll run a background check on myself. Oh, I don't see anything. It's not going to show up. And then lo and behold, the potential employer uses a different company and it does show up. So as I said, I would definitely caution employers to not only, vet the individuals, make sure it's narrowly tailored, that whatever is discovered is really tailored to the job requirement, and to give folks an opportunity, not only as the law requires to explain, but also to talk to the individual, especially if you really like that person, because you wouldn't be running a background check unless you were seriously considering that candidate for the position. That's the only time you really would be running that background check. So it might be worth it to have a follow-up conversation, even if you do find something on the background check. And also keep in mind that you can only ask about, again, criminal convictions, not something that's been expunged, not an arrest record.
Yeah, that's a great distinction.
If I could build on that
Sure.
a bit. One of the reasons, so Helen was, as usual, very thorough in pointing out that you can't do this just as a blanket bar to entry prior to the conditional offer stage. But one of the other reasons for that you need to think about is that the EEOC, so we always refer to a lot of the free resources. The EEOC is the federal government's agency that investigates allegations of discrimination. They have a lot of very helpful free guidelines. One of the things you want to keep in mind about that is that if you're not careful with the way background checks work, you can create a scenario whereby, even though you're not trying to, you are disparately impacting or essentially not intentionally discriminating, but the policy that you have, which is ostensibly neutral, is having the effect of inadvertently weeding out certain types of candidates, people of a certain race, national origin, background, what have you. So that would be one other reason, is it's not just the Fair Credit Reporting Act issues, but if you're not careful and you're big enough, you could end up on the barrel end, if you will, of a class action discrimination lawsuit, not on purpose, but because you were reckless about how you screen for folks and you were too aggressive, and a certain group of people, for example, is disparately prone to conviction history or what have you, just based on whatever neutral criteria, such that you end up getting sued. So it's just one more reason to watch out for it. And the EEOC does have a lot of free, helpful guidelines on that.
Yeah,
Right, that's an excellent point, Max. That if you are going to run these background checks on the person who potentially will be your successful candidate, you should run it on all folks. If you disqualify one and you have to engage in the process again, even if that person interviewed just that much better and you decided to do away with the background check, definitely do the background check if you did it before with someone else.
Sure.
Just to flip it, and this is for all of you, how would you handle if the applicant themselves discloses the conviction?
I think, I think what Helen said earlier is a good way to think about it. At the state of Illinois, for example, and this is a national program, so I'm not using this as the only guidepost, but just as an example, there are certain criteria, I think it's about 6, that you need to consider when a conviction does come up in a background check that you've otherwise correctly conducted. And they involve criteria like, what is the conviction? Like, how severe is it? How long has it been? What were the rehabilitation efforts? How old was the candidate when it happened, their age? And I think those are things I think those are helpful guideposts, because someone who makes a mistake when they're a minor, for example, or even a young adult that is, a blip, if you will, and is not the kind of thing that keeps coming back to haunt them, and they're not getting into trouble, they have a good explanation for it, and they're not presenting a risk to the rest of your employees or your customers or whoever your constituents are. Those are things you want to think strongly about. You don't want to have just reflexive, sorry, you picked up a retail theft when you were 18 and in a bad way, and we just can't have somebody like that working in our, I don't know, like our accounting firm or our what have you. Not thinking of a good our bakery,
We see the words, I often see come up, maybe this is legalese, is interactive discussion.
Yeah.
And this comes up like when, with ADA and family leave issues too, is they have an interactive discussion with the employee.
Well, I
the
think that's one of the
candidate.
benefits of smaller businesses as opposed, I mean, it cuts both ways, right? Like the bigger the business, my experience has been, the more organized they're going to be and the more structured HR process they'll have. But that can cut both ways because then maybe you have ironclad policies that you don't feel you can deviate from because you don't want to get accused of discrimination. But in a smaller shop where maybe ownership or smaller businesses are more involved, in the hiring and firing and day to day, you're in a better position to make judgment calls there, or even in the bigger ones to have some flexibility with it based on certain objective criteria. So I think that interactive process is something that often gets lost from an HR perspective. People get so caught up on what is the ironclad rule. And I think some room within policies for context is helpful.
Sure. Thanks, Max and Helen. Amit, let's take this into a different realm. We're still staying with background checks, but let's look at a different facet of this. Vetting the background checking company. If you use like a third party criminal background checking company, what should an employer do what should an employer do to vet these companies or before engaging one of these companies? What are some of the indicators of a good third party company in this field?
Well, Max and Helen talked about one side of the coin in terms of there can be class actions based upon discrimination under Title VII or maybe your state's human rights law. Separate from that, there could be a class action under the Fair Credit Reporting Act if you as an employer or your vendor is not using the proper consent forms, documentation, etc. And those class actions get filed all the time, and they're very technical in terms of how they're filed. And that can be a huge pain for an employer based on something they may not have done. So I think the best practice is, even if you as a company are using a reputable company that has good reviews or is a brand name in the industry, you can still be liable. So what you should want to do is review the forms that your vendor is using to make sure they comply with state and federal law, and specifically with the FCRA, and make sure you have your own good policy. So whoever is kind of reviewing your employee handbooks or other employment documents, just have them double check the forms the vendor is using too, to ensure state and federal compliance. Otherwise, you could end up in a very messy situation. Maybe there's two different types of class actions you're dealing with, one in terms of your forms and documentation there, and maybe one in form of what Max and Helen were talking about a moment ago.
Thanks, Amit. So Max, in the same sort of realm, what if can or should an employer act immediately if the background check comes back positive, like there's a criminal conviction? And if they don't act immediately, if they shouldn't act immediately, and what should they do then before making the decision to either hire or not hire the candidate?
So it's a good question, Chuck, and assuming that you have followed what the FTC or FCRA criteria are, you should continue to do so. So I think with a lot of the things that come up in these webinars, a lot of it is in what have you done prior to that issue coming up? Have you explained what criteria will be used to evaluate such a conviction when it comes up? Have you made clear the guidelines on what's going to be disqualifying and what isn't? Have you given them, if something does come up or they warn you, have you done the background work to look into it and determine whether that conviction or history is going to be disqualifying? And make sure that you've followed all those steps. I think once that's done, if it's a borderline call or it is a close call, then assuming you've set the criteria clearly, engage in that interactive process. Give them the opportunity to explain what happened and why it should not be disqualifying. I think you also want to consider whether you need to consider whether they've been honest and forthright, or is it something that they've lied about? Because a lot of these state laws and at the federal level, the question is less about are they allowed to, there is the question of can you do the background check, but also some of the exceptions are, well, when they lie about what's going to come up, it can't be disqualifying if there's a conviction of certain types. But if they are dishonest about what that conviction is or misrepresent whether it will come up, that is different as well. And the FTC and FCRA also have some pretty clear guidance as to what happens when you do take an adverse action, and you need to follow those steps. So, for example, you need to give them the notice of the copy of the consumer report, a copy of your rights under the Fair Credit Reporting Act. And as you've given it to them in advance, then they at least have an opportunity to review the report. And then after you take the adverse action, because of that background, you need to then tell them that they were rejected because of what came up in the report, the name, address, and phone number of that company that generated it, that the company selling the report didn't make that decision. So essentially, you're protecting the company, the third-party company, from it, that they're not the cause of it. It wasn't their decision. They were just the purveyor of information. And that this person has the right to dispute the information or completeness of the report and get an additional free report from the reporting company within 60 days. And then just be mindful of your state and these laws, destruction of information requirements and how long you need to retain the information, because that can come up as well.
Thanks, Max. So Helen, let's change gears on this and look at a different aspect now of hiring. Job descriptions, are these important? And if they are, why? And what goes into making job descriptions?
Job descriptions can be important. It really kind of depends on the situation. The reason why I say it kind of depends is that, if it's a really small business, and let's say you don't have a lot of employees, and employees often do a lot of different kinds of jobs, and you're very clear at the outset that you might be required to do other jobs, and it turns out you do more of one kind of job than another kind of job. It might not be let's say, as important as let's say someone who works for a larger company, when let's say they're hired as an executive or have certain type of executive functioning. Those job descriptions in terms of the executive functionings are spelled out. They relate to the exact title that the person was hired to do. And if at the end of the day, the person does not actually perform the job that they were hired to do in that executive capacity, then you could potentially have some sort of a breach of contract, or you could have some sort of other type of complaint that could have some legal liability, as opposed to just a disgruntled employee who says, look, you hired me to do X, Y, and Z. I'm not doing X, Y, and Z, and I'm really upset about this. So that's why I said my answer is kind of depends and a little bit wishy-washy, because it's really kind of a contextual thing. I know when often I assist potential employers, I always tell them, when let's say they're describing the job in an employment agreement, to leave some room for an expansion of the position. So I'll add language such as or any other task reasonably required by the employer, or another task that's related to the aforementioned, or something to that effect, to show that it's not 100% black and white, because often jobs are fluid and they do change with business needs. So sometimes a job description that maybe you posted that the person applied to and has been working in 5 years or 10 years isn't so relevant 10 years later. So that's why they can be important, but not necessarily. I think the important criteria is to show that you're not discriminating, that it's not some sort of a bait and switch, that you're very open about it. But again, when putting together a job description, I would have it match the title, and I would leave yourself an opening to be able to change some of the tasks on an as-needed basis that are consistent with the job requirements, that are consistent with the internal needs of the company.
Thanks, Helen. So let's now look at another aspect or different dimension of pre-employment hiring, screening. And let's go with you, Amit, on this one. Classification issues. Many employers like to use independent contractors as a way to save money on taxes and insurance. But there's a lot of factors that go involved into classification. What are some of the key factors an employer should consider when deciding whether to use a contractor or whether to whether to classify as an employee?
To me, the analogy sometimes is, do you want to change a diaper or do you want a car in your living room? because if you get the classification issue wrong, it's going to be a huge headache. I think sometimes companies try to use a patchwork solution and end up in a much bigger mess than they otherwise wanted to, just because they're trying to save a little bit of money on the employer side of their taxes. The courts, the IRS, the Department of Labor, other governmental agencies like unemployment use different tests to determine whether or not someone is a W-2 employee or a 1099 contractor. So the cost can be astronomical if you get that question wrong, because what ends up happening then is each of these agencies are looking into, well, is this classification correct? They may be doing an audit. You may have an employee that then ends up filing a lawsuit on behalf of several people. So you end up in a class or collective lawsuit situation. So initially, the company saves a little bit on their tax burden and then ends up in a much bigger headache that's much more expensive. And they're either on the other side of an attorney threatening a lawsuit, or they're calling an attorney to do a wage audit. So my approach on this is to determine if the worker, if the individual is really going to be a separate business, and whether the services are materially different than what the company actually provides. So for example, if as a law firm, we're hiring someone to fix their copier, that's a separate business. That's an independent contractor. If we're hiring a marketing company or an IT company, that's similar. It's likely they're not providing legal services. That's a separate business, and that can be a contractor. But if the 1099 person or whoever is providing services that are pretty similar to who the W-2 employees are, that classification should be an employee. And if there's gray area, it's just not going to be financially worth it to bring that person in as a 1099. Because again, that company may save a little bit in the short term, but the long-term headache is going to be astronomical, and the cost savings aren't going to be worth it.
By the way, last week I was looking at some employment agreements and pre-employment documents for a client's wife, and this was for a medical practice. They were going to hire the wife as a nurse, and one of the documents said, as our employee, this is what you're expected to do, blah blah blah, and then one of the other documents was independent contractor agreement. So I pointed out to her, you better get some clarification on this, because it sounds like they want you to be an independent contractor, but yet they're going to treat you as an employee. So be careful of all that. Bottom line for all you employers out there, don't arbitrarily classify, do the analysis.
Yeah,
That's
at the end of the
interesting
day,
point. Yeah.
the government's going to want their
Sorry.
money. So, sorry, Helen.
No. What I was about to say is that's a really interesting point, Chuck, that you raised, because I have seen that a lot especially in the medical practice or whatnot, because often a lot of these folks are treated as independent contractors. And I think what's happened over time is they've either heard through the grapevine, or they heard from a lawyer at some point, listen, these folks really need to be employees. And so then I get these agreements, and they try to change a word here and they try to change a word there, but essentially it's really written as an independent contractor agreement, even though now they want to treat these, or now they want to at least technically on the surface treat these folks as employees. And here's what I would say: don't be cheap. Hire a lawyer to revise your documents. Don't try to convert your independent contractor agreement into an employment agreement, because there are a lot of nuances you don't realize that actually show you are violating the law, and the very thing you're trying to do, which is comply with the law, which is why you're converting them from an independent contractor to an employee in the first place, is just undermined by how poorly your agreements are then drafted, like with expense reimbursements and all sorts of kinds of things that are very clear. They'll put language in there like, you're responsible for costs, you're responsible for expenses, you're responsible for this, you're responsible for that. Well, hello, not if you're an employee.
And by the way,
I want to echo that one point, Helen, which is you pay for what you get for it. If you're downloading some stuff off of Google or whatever, your agreements likely aren't going to get you very far. I've definitely seen like employment agreements, restrictive covenant agreements, etc., where someone found it somewhere and it's missing so much information that it's critical to protect the company.
And by the way, I think it's a good idea for employers not to give independent contractors job descriptions, going back to what we were discussing earlier. So, Max, let's look at another layer of this. The classification of employees as either exempt or non-exempt under law, and this relates to overtime compensation. So employers try to evade overtime by classifying their employees as being exempt. What does this mean, exempt, non-exempt? What laws are we talking about?
So again, we're going to the same laws we were just talking about from the wage perspective, the Federal Fair Labor Standards Act, and then for quite a few states, there's state or municipal local wage ordinances that often pretty consistently, at least in part, mirror the FLSA. So you want to start there and make sure that whether it's your HR department, if you have one, or whatever attorney is advising you on these things, that person, and I guess one recommendation I'll make is not your accountant, because I cannot tell you how many wage and hour lawsuits I've brought where the employer's defense was, well, my accountant told me I could do this. And it's like, I understand, and I'm sure your accountant is very good at keeping you away from IRS audits and making sure you pay your taxes, but they're not a labor and employment lawyer. And I hear that a lot in discrimination cases too. I don't know why people think accountants can give employment law advice, but they really ought not. I'm sure they're very good, what they do, but you want to make sure that person, whoever it is that is advising you, is up to speed on these different laws, because while the laws themselves have been in effect for decades, the regulations and the tests that they employ do sometimes change. The Federal Department of Labor will issue guidance or revise or propose regulation changes that will alter how the tests operate. So I think that would be the starting point. More broadly, there are other places you can look for the information, and I will give some of that information. U.S. Department of Labor has great fact sheets available. The Fair Labor Standards Act is one of the laws with the most robust and useful regulations out there that will give you actual examples from cases or lawsuits that have been decided at different levels of our federal court system on what is acceptable and what is not, as to these different exemptions from overtime requirements. So those are just sort of big picture suggestions as to all of that. In terms of specifics, generally, the most common exemptions we see are in like certain industries, like the logistics or trucking industry. Most, but not all, employees involved in what we call safety affecting activities will be exempt from overtime. But an exception to that is, by way of example only, dispatchers. And that was a case I had where somebody was sent to me about a bonus that he didn't get. And I was about to not take the case, and I asked him how he was paid. And it turned out he and all the other dispatchers were working 50-hour work weeks on a salary basis on top of some unpaid mandatory meetings on Saturdays. So the next thing you know, this company that basically stiffs somebody on a $5,000 bonus has a 9 or 10 person, what we call collective action, unpaid overtime lawsuit that ends up getting resolved at many factors larger than that after a lot of exposure, because they were sloppy about how they applied that overtime exemption. Some of the more common ones that I think that are less industry specific are the professional exemptions. So like executive and administrative exemptions, which I know we will talk about in more detail on whatever episode our wage and hour webinar is. But you're typically looking at what sort of independence and autonomy does somebody have in decision-making within the business? Are they doing something that Amit talked about earlier, which is the core mission of the business, is the widget factory? Are you involved in the widget making, or are you involved in the back office and you have discretion within that as to that business? What are the earnings? There are minimum salary or salary equivalent floors that are set by these different exemptions. And then a few other factors, exemption specific as to what your duties are. So I think the long answer to the short question is check the regulations, have a robust HR department, or a good and experienced employment law attorney who knows wage and hour law and can steer you away from trouble there.
Thanks, Max. Helen, moving on to another layer of this, defending failure to hire claims is a really expensive and difficult aspect of pre-employment hiring and running a business. If an employer intends to cite an applicant's lack of qualifications as the reason for not hiring them, how should that employer then really go about screening applicants for those qualifications? I guess this gets into like the acronym KSAs, knowledge, skills, and abilities.
So I'm going to share a common theme that both Amit and Max and I and you have addressed, which is try to treat people similarly. That's the best way to keep yourself out of trouble, with few exceptions. Okay. But with few exceptions, really try to treat folks similarly. So for instance, you have your screening process. Try to uniformly apply it to each candidate with whom you're interviewing. Ask similar questions. When you're interviewing the individuals, look for similar criteria in reviewing the resumes as best as you can. Try to be able to justify why you hired a certain individual. I had a potential and maybe some of the other folks on this call saw this also. I think a number of us are members of NELA, the National Employment Lawyers Association, and I think someone made a post one time, a kind of interesting post, which is that an individual was involved in the hiring process at the company, and the company may have had good intentions for DEI, diversity, equity, and inclusion, and wanted to hire someone from a specific type of a protected class. Okay. I'll just say that, you know, maybe they want to hire someone Hispanic, whatever the case may be, it doesn't make a difference. And so they had their, you know, interviewing process and so on and so forth. And it came time at the end of the day to hire someone. And because this company so badly wanted to hire someone from a specific demographic, that they actually ended up hiring someone with less qualifications than other candidates. And someone on the hiring committee pointed this out and said, you know, hey, I thought we want to hire the best person possible. We're not benefiting, let's just call it the Hispanic community, just by hiring someone Hispanic because they have Hispanic in their name. If they're not qualified, it doesn't do anything for that individual. And it turns out that the individual who was on this committee complained and was terminated. And now that individual potentially could have a retaliation claim because the person engaged in protected activity and said, look, why are we doing this? Why are we hiring someone based on a specific demographic as opposed to the best person for the job? Isn't that discriminatory in and of itself? And they found that they were on the way out the door in that situation. Yeah.
I'm sorry, I thought you were done. Go.
No. I was saying. So, you know, again, it's hard because when you're interviewing someone, you develop a rapport and then you kind of go off your script. But even if you do go off your script, try to remember some of the questions you asked other candidates, you know, and also make sure you avoid the illegal interview questions. I mean, it's really easy when you see, let's say, someone coming in who, let's say, looks like they're 6 months pregnant to say, oh, when are you due? But you will have just asked an illegal interview question. So unless the individual actually mentions, oh, I'm pregnant, what is your pregnancy policy? You have to ignore the fact that someone has this ginormous belly sitting in front of you. And especially if you're not going to hire that individual, they're going to say, gee, I don't think I was hired because I was pregnant. So it's really a very, very tough balancing act when it comes to the screening process.
The one other thing I wanted to mention, and this is a little esoteric, so bear with me, but the more I do intent or discrimination work, there are types of claims people will bring sometimes about stereotyping, which are an impermissible form of discrimination. But one way I sometimes see this happening is there's this notion, and we'll talk about the discrimination laws on the appropriate webinar, but in more detail, but there's this notion of people having to prove themselves, and Helen was talking about, you know, treating everybody equally. But one of the common things you will often see in these various situations is where certain groups are not required to prove themselves, that if you have equal applicants, typically the stereotype, right, would be a white man and a female candidate or a candidate of color or some other minority persuasion, and their qualifications are equally strong or not strong, you get kind of these unconscious biases of, well, this person's not spoken for, they have to prove themselves to get there. And so even when you think you're doing it neutrally, you want to make sure that you want to check yourself on that point, basically. It's a little nuanced and it's not as obvious, but as you go through the hiring process and you are asking the same questions, that's just something I've seen a bit of. That's not always as obvious, but when diversity is something you're pushing for, it's something to be mindful of.
Thanks, Max.
Now, I want to also, I want to also be specific too. It is okay to have very specific criteria. So for example, if your job requires you to work with, let's say, a certain immigrant population, and so language is important, let's say being able to speak Spanish, it's okay to say you must speak Spanish for this job. It's not okay to say you must be Hispanic to get this job, okay? But it is, if it's a legitimate job criteria, it is okay to specify that as part of the job description, as we discussed before.
Great point, Helen. Thanks. So, Amit, let's go back to employment agreements, but let's look at this in a different context. If an employer's in the hiring process and the candidate discloses to the employer some sort of restrictive employment agreement, non-solicitation, non-compete, whatever, and this comes up during the interview, how do you recommend that the employer proceeds?
Yeah, this is why this area of law becomes bipartisan. Because again, companies need to hire folks. So there is both a business and a legal risk to hiring someone with a restrictive covenant. From a business standpoint, a company's not going to want to hire someone who is going to be distracted by a lawsuit or maybe can't work due to a court ruling. Legally, there could be a claim against that new employer about interfering with a contract or maybe an allegation of theft of key information. So regardless of any enforceable non-compete or non-solicit, one important best practice is to communicate to any candidate is that you do not expect them to bring any confidential information to a new job. In fact, they should be instructed not to, because the last thing a new employer wants is the old employer's stuff. That is the easiest way to get into a lawsuit. That's going to be a huge headache. And then I think for any non-compete or non-solicit, there's just a multi-step process companies should be going into. Does the covenant even apply to the new job? Is the role going to be completely different in different territories, et cetera? Can the prospective employee, the candidate, can they get a waiver from the former employer? Are there other solutions to ensure compliance? Maybe you can carve out certain territorial areas. You can change the job in terms of what the scope is going to be, so it's structured in a way that it doesn't violate anything. What's your legal team saying? Do they have an attorney opinion saying, we don't think this is enforceable, or we think there is some other solution? If the candidate is critical enough, can you negotiate with the former employer, with the business? Maybe there's some other solution you can come into business to business. And if not, if the person is that important, are you willing to litigate the issue? Sometimes a company may want to do what I call a forced acquisition. They may want to get a candidate and some of their book of business, and you can put together a game plan and, you can piece it out in a way that's strategic for you and a new hire. That both minimizes your risks and maximizes kind of your business opportunities. But again, it's my theme on this is always the business folks and the legal folks have to talk to each other so they can come up with a good strategy that makes sense for everyone.
Thanks, Amit. Max, different topic now. What do you do with rejected candidates in the hiring process? Do you notify candidates, that they've been rejected? Do you keep records of rejections? And if so, how long do you keep them?
So two separate answers. As to the first part, what do you do with rejected candidates? I think that depends. I personally think it's polite to let them know if they don't get the job or give them some finality so people aren't just hanging on the edge. Practically speaking, I think it's a question of what expectations do you set. I'm a broken record, but tell them up front what to expect. If we think you are a good candidate to move on in the interview process, we will contact you within X period of time. If you haven't heard from us by 3 weeks from now, a month from now, assume that we've moved in the other direction. Or if you do like to tell people and you want to at least give them some closure, you can go that route too. Just again, set expectations as to when they should find out. As far as how long you keep the information, you want to make sure that you are following federal guidelines. Again, the ADEA, Age Discrimination and Employment Act, and Title VII apply to businesses with 15 or more employees. Typically, the law requires you to keep those sorts of applications for a year or more, I believe, about a year. Usually, I think that is tethered to the statute of limitations on those laws being about 300 days to bring a charge. So people have the opportunity, I guess, to bring that claim if there is an allegation of discrimination. But it's also just from a practical standpoint, good to keep good records of who's been applying, even independent of that.
Thanks, Max. So we're almost at the top of the hour, and Helen, you get the final question. So if an offer is made over the phone and accepted, do you, as an employer, should you also make that offer in writing? And what should you say? Yeah, and then what do you say to them? No problem.
I would say it's very important, even if it's a bare bones offer letter. I know that the slide that we're showing right now gives like a few salient points. Even if it's just those salient points, it's very important to put that in writing because, for instance, some states do have requirements of certain things that must be put in writing to employees, such as when they expect to get paid, how often they're going to get paid. What is the schedule for their job. So I would say that yes, it is very important to confirm, I would say, in writing the terms of employment, the salient terms, such as the pay expectations, the wage, the compensation, if there's going to be a certain schedule or whatnot. And it's perfectly acceptable to put in the offer letter information such as you are expected to follow the policies and procedures of the company. More information about benefits will be in our benefits book and will be subject to those terms. So it's fine to reference other documents that might be important or that might apply to the job. It's also important, especially if you are, which I think practically every state is, an at-will state, to mention that the employment is at will and that there is no term of employment. And every once in a while, someone's not at will. You know, like let's say highly compensated executives, C-suite executives might have an employment contract or employment agreement. So especially for those, it's important to put those kinds of terms. So the quick answer is yes. And what goes into it, of course, is always subject to many different interpretations. But there are some basics, and that slide that you had essentially puts the bare bones that should be in writing to your new employees.
Thanks. We're at the top of the hour. Does anybody else want to make any final points on what we've discussed? Cool. So everybody, thank you for your participation in this. We come back for our second webinar in the series on February 22nd, and that's an ounce of prevention, policies, procedures, and handbooks. So look forward to seeing all the panelists and attendees then. Thank you.